Good evening. Right now, Metro Police are desperately searching for the person or people responsible for killing a man and a woman.
I got a male down in the middle of the street.
Breaking news now, a triple shooting leaves 2 dead.
Never expect for somebody to tell you your loved one was murdered.
This Labor Day will mark 42 years that have haunted the St. Cloud family.
30 years. 30 years this family has waited for answers.
A couple months go by, 3, 4, 5, 6, and you really start to struggle with the idea that the case might not get solved and that somebody might get away with murder.
It's very unfortunate that we have any cold cases at all, and certainly unfortunate that we have as many as we do. And that's why Ryan's work and the work of Project Cold Case is so important.
Good evening. Thanks for joining us tonight. I'm Ryan Backman, founder and executive director of Project Cold Case. Joining me tonight is Rich Komando, former prosecutor, assistant state attorney. Thanks, Rich, for joining us.
Thanks so much for having me tonight.
Yeah, we've been doing this. Is now the second week we've done this, where we're kind of taking a new approach, and we're going to create a series of workshops, hopefully later in the year, where we will do some e-vites or e-brights or whatever it is to register potential followers that want to learn more and have a more intimate setting, ask more questions, get more specific. But for right now, we're just doing it through these lives, and we're kind of doing a little test to see how much engagement we get with people who's interested in these topics. And important, really important in the world of cold cases is getting outside perspectives. So as victims, survivors, we know what we are experiencing. Sometimes it's always comforting to hear other people are experiencing something similar. But sometimes we need to hear the law enforcement perspective, the prosecutor perspective, and it helps us get an understanding of why our case maybe is in the status that it is. So tonight we're going to talk to you about some of those things, and try to get a better understanding of the judicial process, because that is something that is very confusing for those of us who have never experienced it, never been a part of it. And for somebody like you who has been in and out of courtrooms for the last 20 years, it's just second nature to you. So you can shed a lot of light for people like me and families that we serve. So that's our goal here tonight. And I appreciate your willingness to join us and share in your experiences and your perspective and help us to educate those that might have questions and might want to learn a little bit more about that process. So to get started, Rich, could you give us a little background on yourself, where you went to school, why you wanted to be a lawyer? Did you want to be a lawyer? And then a little bit about your time at the state attorney's office.
Sure. I mean, I went to Florida State, and in undergraduate, I thought I either wanted to be a federal agent or I wanted to be a prosecutor. So I studied criminal justice and went on to law school at Loyola in New Orleans. Coming back, I took a less traditional route. I was in private practice for a number of years. And then I worked with the Guardian Ad Litem program with abused, abandoned, and neglected children. And then after doing that, I was able to actually work for the state attorney's office and come in as a prosecutor and have a really different perspective than what I'd done in private practice and what I'd done working with abused children. And as you said, it's a lot more kind of in-court intensive, and most of the world out there doesn't have any sort of experience with the court system, which is probably a good thing.
Right.
But for somebody that doesn't walk in every day, it's intimidating. I mean, there's 15-foot ceilings. You've got the raised bench. I mean, everything about it, if you're not familiar with it, can be very intimidating to someone walking in.
Definitely. And you worked for the state attorney's office, and you prosecuted some homicides, including some death penalty cases in your time there. I know because I was a victim advocate, and I was sitting in those courtrooms on a number of occasions while you were working and while you were prosecuting those crimes. But that's not the only place our paths crossed. Originally, when we met, you were the chair of the Mayor's Victims Assistance Advisory Council in Jacksonville, and I willingly at the time applied to become a member of that council, and we worked on that council together for a number of years, actually up until just a couple of years ago. So you've always been victim centered. Obviously, you talked about your work with guardian ad litem and children. You do work with the child protection team in Florida, and obviously you work with us a lot. You are on the board of directors for Project Cold Case. So you have a vast knowledge of the law, but you also have a vast knowledge of victim issues. It's nothing new to you when somebody comes forward and says they're having a problem with communication with law enforcement or understanding the judicial process. You've handled those questions for years now. So let's jump in. If anybody has any questions that's watching, please type those into the comment box. And Clint from our office is also, he's going to organize those questions, and we may answer some as we go, depending on, we've got a couple topics we want to address and talk about, and then we'll leave some time at the end to answer those questions. And if one of those questions happens to come in line with what we're talking about, we'll address it then as well. So let's jump right in, Rich, and talk about some of the issues in a prosecution. And let's go under the assumption, obviously here, we deal with cold cases where there, at least at this point, isn't an arrest. But sometimes, we are lucky and we get an arrest in these cases. I think we've had 9 or 10 this year that we featured on our site that have been solved. And so the family then goes from having, not knowing what's going on and not being in the courthouse to being thrust into that criminal justice, maze, if you will. And we don't stop assisting those families just because an arrest has been made. Then we try to help them navigate the court system as well. So let's go under the assumption that one of our cold cases has been solved, an arrest has been made. And what I want to talk about is how long it takes. A lot of times people, you've waited 20 years for an arrest in your loved one's case. You get that arrest, and then you kind of think that, okay, when's trial? Next week, next month, 2 months from now? But that's not the reality of the judicial process. Those wheels of justice, they turn, but they turn slow, and so let's talk a little bit about, of course, first and foremost, a speedy trial, and maybe you can explain that to us. But then if speedy trial is waived, what that usually means for the length of time before a trial.
So, whenever a criminal arrest is made, the prosecutor is under an obligation in a felony case to bring that case to trial within 6 months. And even though that sounds like a long period of time, probably more often than not, you're going to see that the defense attorney is going to waive that speedy trial. They're going to give up that right to have the case brought to trial within 6 months. And the reason they're going to do that is because usually there's more discovery that has to be reviewed. There's more documents. Sometimes you're waiting on independent laboratory results to confirm something. I know this may shock you and the people watching tonight, but most defendants that I've ever worked with, either as a prosecutor or a defense attorney, don't come out and just admit that they did something. Sometimes even when there's a confession, they still deny that they had any involvement. And, the defense side has a requirement to try to protect those rights. And you kind of alluded to it already, but in a lot of different aspects, the criminal justice system is very defense focused. Florida was really one of the forerunners back in, I think it was 1986, where they passed the victims' rights laws that then required for victims to be informed, present, and heard at each critical stage of the judicial proceedings. And I don't even know that all states in the 50 states have that today. Yeah. But understanding that, up until 1986, which is pretty astounding in a lot of ways, the victims were really kind of disregarded unless the prosecutor or the detective reached out to help somebody. So even though victims are an important part of the process, when you get into that actual courtroom, you'll notice a lot of the focus is on the defendant and what the defendant's rights are.
Yeah. And I mean, that's, when we talk about the U.S. Constitution and the what was written, the laws that were written into our Constitution, it was to protect people from being falsely accused, and so while a lot of guilty parties take advantage of that right, and that ability to have those rights that the falsely accused are there to protect. They're there to protect our citizens. That's what those constitutional laws are there to do. And so when a defendant they take advantage of those. And then a lot of times it will spread the trial out from, I know we used to tell people from the time of arrest to trial date, don't expect anything within the first year and a half, probably closer to 2 years from the date of arrest, and inevitably families either didn't want to hear that, or they, conveniently forgot that. But the frustration would start when the next month they would go to trial and they'd have a status hearing or a pretrial, and the judge would say, state, how's it going? Defense, how's it going? And they would reply, good. And then the judge would say, okay, come back next month. And then the next month they'd come back for the exact same thing, and the families would start to get frustrated, and so we would spend a lot of time, trying to assure them that was the norm. That was what to expect. And you were to expect that for, at least a year and a half. And we had trials that, took a lot longer than that before they actually, went to trial, went before a jury. So, we are always trying to, help families understand that this is a marathon. Each of these segments of this journey is a long stretch, and so not to get in a position where you're expecting something short of that. Obviously, if they don't waive speedy trial, then that changes everything. But trials take a while. They take a while to prepare. Defense attorneys usually want need that extra time, like you said, to prepare for expert witness and expert testimony, and get their own evaluations of their clients, and stuff like that. So it's a long, drawn out process. We talked about this a little bit earlier today, that you need to lean on, like, a lot of state attorney's office, district attorney's offices have advocates working for them as well, and those are your keys. And we talk about it a lot, whether it's the police agency, the investigating agency, police, sheriff's office, police department, or whether it's the prosecuting office, state attorney, district attorney, commonwealth attorney, whatever it is. Most of them have an advocate or a staff of advocates that can assist and can get you information. So always encourage you to develop relationships with those individuals, because, and you can, talk about this too, Rich, like, you used your advocates. Some attorneys, they feel like they don't need them because they don't need them, but a lot of times the family needs them. And so you were known to lean heavily on the advocates in your office. And I think that helped you as well, because you weren't coming back to your office with 15, voicemails that were just the family, asking for an update. Could you let the advocates handle that part of it?
Well, and they do a good job. I think, keep in mind that when you look at some of the caseloads in different cities, obviously the closer you get to a bigger city, the more challenging your caseloads are. You have a lot of different things to try to juggle. And, sometimes you have a number of different cases on the calendar that day, and your family or your victim may have questions, and it's hard to go talk to them in between your multiple hearings, or sometimes you have to be in multiple courtrooms. And a victim advocate is a good liaison that helps explain what's happening in the process. When you're talking about how long it takes to get a case to trial, homicide is understandably a little bit more complicated than some of your petty crimes. And I think part of that is, as a prosecutor, your job is also to protect the record. You don't want to falsely accuse somebody. You don't want to falsely imprison somebody. And on the flip side of that, when you do have a case where you're confident, you have the proof, you also want to make sure that conviction sticks. You want to make sure that you've presented a case in such a way that it's not going to come back on appeal, because that further traumatizes the family. And as you talk about the process, when you walk into that courtroom the first time, I think some of it is, as you talked about, that lack of familiarity. A lot of times, judges set deadlines for lawyers. Lawyers are just like anyone else. We're very deadline driven. So when you walk into a courtroom and you hear the judge say, okay, we're setting you for trial, how much time do you need? And somebody says, well, I'm going to need 3 months to read through this. And the judge says, sure, no problem. We're going to set the case for 3 months. I think if you're not familiar with the process, you think, okay, well, the case is going to trial in 3 months, where from a prosecutor or defense side, there's close to no chance in the world that case is really going to go to trial in 3 months, because something will develop in between that time period, and there will be some other reason why additional time is needed. And sometimes it's on the prosecution side. You work on cases, cold cases bring another particular issue where, we're not in the day and age that our grandparents were, where when they work somewhere, that's their job for life. They're going to be there from the day they turn 20, whatever, until the day of retirement. I mean, we have a very fluid kind of workforce. So, law enforcement moves around, witnesses move around. And if it takes 5 years or 10 years on a cold case to make an arrest, and then you're looking at trying to find witnesses, it's not uncommon where those witnesses are literally scattered across the country, then trying to coordinate their schedules to get them in, then trying to go over prep time to make sure that they remember what their original observations or testimony were. Those things all play into kind of the length of time it takes to get one of these cases to go to trial.
Yeah, I mean, and Mariah is asking some good questions, so I want to, and we're kind of pertinent to what we're talking about, so I want to jump in on those too. But exactly what you said. I mean, when we're talking about cold cases, I mean, all of our fear is that by the time an arrest happens, that witness, that star eyewitness has died, or, they're incapacitated somehow, or they're sick and they can't come to trial. I mean, there's all of these fears for us that each day that goes by makes that conviction even harder. And so one of the things Mariah asked originally was, how are cold cases handled or treated? And so I want to kind of, again, talk about the difference between, or for the first time, maybe we should have started with this, the difference between the investigating law enforcement agency, the police department or sheriff's office, and the state attorney's office and the prosecutors. So typically, and again, when we talk, we're trying to, everywhere is different. Every, jurisdiction is a little bit different, but we're trying to put together the most likely scenario and how it typically goes. But keep in mind that this could be different if you're in a small rural area in Alaska versus a big city like Jacksonville, in Florida. But the sheriff's office or police department is investigating those cases, and how they handle cold cases is one thing. Typically, the state attorney's office, district attorney's office doesn't necessarily get involved until an arrest is made. I mean, I know, like, kind of the caveat to that is here in Jacksonville, and I know in some other jurisdictions, a prosecutor will be assigned to like a homicide, on call schedule. And when a homicide happens and that prosecutor is on call, they will report to the scene. They will respond to the scene at the same time that the homicide detectives do. And that can be very helpful in a prosecution. However, it's really only helpful if an arrest is made and that prosecutor stays on that case throughout. As you just mentioned, though, that's not always how things go.
Well, it's helpful in a couple ways. It's helpful, one, because again, you have to remember that the perspective of the prosecutor when they show up at the scene is they're thinking immediately of chain of custody. They're thinking about who touches, can the scene be contaminated, all the things that months down the road could end up as a basis for a motion to suppress, or a basis to throw out some piece of evidence that is really critical in trying to prove the case. So they're looking at very technical aspects. They're not there. I think maybe there's sometimes a misunderstanding. They're not there to supervise the detectives. We're not there to tell them what to do. I mean, they're professionals that are trained expertly in a lot of different aspects of criminal investigation, but we're there where if something needs to be open to do additional investigation, if it's a room or a building or a car, we want to make sure that we get an appropriate search warrant so that later on that piece of evidence, if something is found, doesn't get thrown out.
Yeah, absolutely. I mean, this is the stuff that is so important for people to understand, because you're going in with a different perspective than the homicide detectives.
Mm-hmm.
And so while you're both on the same mission and on the same team, you're not necessarily coming in with the exact same focus. And so kind of, to answer, that portion of Mariah's question, really when it comes to then cases going cold, they're going to be handled by the investigating, police department or sheriff's office, not so much by the state attorney's office or district attorney's office.
And that depends on the office too. I mean, not every office has what we'll call a cold case prosecutor. I mean, I was fortunate in Jacksonville, and Ryan, you worked with them as well, where Jacksonville's had a cold case prosecutor. And, a lot of times that prosecutor will kind of be a little inventive, where they look at other cases that are around, and sometimes they'll ask fellow prosecutors, or, I've seen them even go to the jail where they go talk to different inmates saying, hey, look, so-and-so, there was a murder a year ago, this part of town. Any chance you know about it or you heard about it? You're from that part of town. There's no way you didn't know about it. And those things are fantastic for offices that have a cold case prosecutor. But unfortunately, I think that's probably more the exception than the norm when you look at different district attorney or state attorney's offices.
Absolutely. I think we hit on Mariah's comment about a question about how long it takes. I mean, the minimum is if speedy trial is not waived, 6 months, in Florida.
Yeah, I've never seen one move that fast. Usually, I'd say on a rapid timeline, you're a year and a half, 2 years.
Right. And so, but keep in mind that, I mean, we sat with a family a couple of years ago that was, it took 6 years from the date of arrest to get to trial. Now, it was a very complicated case, and the feds got involved and ended up charging the suspect with a drug charge that ended up, kind of taking up 2 years of the wait, while they focused on that charge. But it was not, it's not common, but it wasn't unheard of for a case to go 4 years from arrest to trial. So you can imagine it's going to be somewhere in that range. And right now, with COVID and in-person trials having been halted and then started and halted, depending on where you are, that's just creating a backlog of cases that were ready to go, last March that haven't gone yet. So
Right.
We're going to see it take, I think, a little bit longer for these cases to actually be resolved that are in the judicial system and in the process. So Mariah then asked, I think this is important. It was one of the things we were going to talk about anyway. Does the state attorney offer plea deals to murderers and cold cases? And that's her fear, that would not be justice. And I think this is a really good topic, because I think sometimes there's some misinformation out there about what a plea deal, whether that's justice or not, right? So I think, again, remember that we can't be case specific, because Mariah, unfortunately, we don't know your exact situation right now, but we can talk about cases that we have, that I've advocated for the family and that Rich has prosecuted, and share some of our insight from that. And again, this is just our perspective and our opinion. So you can take this, with a grain of salt, however much you want from us. But yes, prosecutors can offer, can accept plea deals and offer deals in cold cases. And I know you said that scares you. Sometimes that is not the worst thing. And, from my perspective, and I want you to talk about it, Rich, but from my perspective, going back to what we mentioned about, when you're 10, 20 years, 30 years removed from the murder, your evidence is degraded, your witnesses have disappeared, or their memories have faded. There's a lot more that can go wrong in a jury trial that you don't have to worry about with a plea deal. But let me get your thoughts on that, Rich.
Well, and I think it kind of comes both directions too. I mean, as a prosecutor, there's a number of different times and scenarios where like you talked about, the length of time that it takes to kind of get a case towards the point where you're close to trial. There are many times where the victims are asking us to enter a plea deal. I mean, emotionally, it's exhausting. If you think about the events that have happened that have kind of brought you to the point where you even get close to trial, some people are just physically, emotionally, mentally worn out. They literally can't sit through and weather a trial, no matter what the outcome would be. And sometimes as a prosecutor, it's our job to take a look at kind of what the victim's wishes are. It's part of those victims' rights laws, but also to take a look at kind of what the impact would be to the victim, to the victim's family. And, when you talk about plea deals, for the most part, one of the things as a prosecutor that I think about is it significantly reduces the ability to appeal. In order for somebody to take a plea deal, they have to admit that they did something. That is a much harder position for them to later claim that on an appeal that a case should be reversed. Where when you take a case to trial, there's much more opportunity for someone to later claim that either a piece of evidence came in or something was improperly done as part of the trial, and that case will get appealed. Now, there are cases where when you're looking at first-degree homicides, there's very little chance that that is going to end up in a plea deal. And the reason why is because for the most part, whatever the states offer is going to be is the maximum penalty. So there's no reason for a defendant in that circumstance to ever want to enter a plea deal. But for example, if you have a death penalty homicide in the states that allow that, sometimes the plea deal is for them to plead to life without the possibility of parole. So there's a lot of different considerations, and your victim should be included in those discussions as to whether or not a plea deal is appropriate for a case. Like we talked about, if there's a motion to suppress that somewhere down the line gets granted, if a critical piece of evidence, does it mean that the case goes away? Probably not. Hopefully there's other types of circumstances, witness and evidence that'll help prosecute that case. But when it significantly affects the strength of your case, that's when you start trying to figure out if a plea deal is a more effective way to obtain justice for the family and for our system as a whole.
Yeah. And I think it's important to know that, like you mentioned, a plea deal doesn't mean we're not saying that you offer up 2 years for a murder. You know what I mean? A plea deal still should have a very lengthy sentence attached to it, as if you have all of the elements you need to successfully prosecute it. There's no reason to offer a plea deal that is so lenient. And so I think that's, again, having a good relationship with the prosecutor and the advocate within that office to have candid conversations about what evidence, the state has, what they're able to prove, and what are the benefits of a potential plea deal. I sat in on a trial with a family, and the trial started on Tuesday, and we went to Friday morning. We walked in for closing arguments. The family was exhausted and drained, and the defendant had been, obviously proven guilty without a doubt. And as we were walking up to the courtroom doors, the prosecutor came out and said, "We need to talk. He wants a deal." And the defendant had, after sitting through his entire trial, had realized he was quite likely going to get life in prison. And he decided to kind of throw a Hail Mary and ask if the state and the family would accept a plea deal. And in that situation, and no judgment here on families, whether you feel compelled to continue, to trial and fight for trial or accept a plea deal, even after everything they had gone to, they accepted that plea deal. And to this day have not regretted that decision, because of what Rich explained, that when the defendant accepted that plea deal, he also accepted that he basically could only appeal the legality of that sentence, that he agreed to. And the judge stood there in front of him and said, you have been informed of all your rights. You're making this decision of your own free will. You're not under the influence of any, pills or medications, and you're making this decision. You're pleading guilty because you are guilty. And this defendant has to go through and answer every single one of those questions. And it really creates like an airtight, like now you're going away to prison, and the family is not going to get that call in a year that says, hey, guess what? The appellate court threw out the confession and now we have to do a trial over again, without it, or something like that. So it's really hard to just talk about one specific area, but don't fear a plea deal. Educate yourself on a plea deal. Don't feel compelled, one way or the other without knowing all of your options and facts. But do know that in some situations, a plea deal is actually a good thing for the family, and and it doesn't always mean that the defendant was going to get out or get out quickly. So I think that those are important things. I know we have some people asking questions about the investigations and detectives, but that was something we really talked about last week that's still on our Facebook page. If you scroll back to last Wednesday's Facebook Live, we had a homicide sergeant talk to us, and and you can also call our office, because that's something that we can help with, when it comes to detectives that are not being very communicative. But we're going to try to keep this one on prosecutions. Donna asked, what is first degree murder? What do you have to meet to get first degree? I think that's a good question, because a lot of times families attach a value of their loved one's life with the degree of the charge, and the degree of charge has nothing to do with the value of the victim's life. So Rich, can you?
Yeah, I mean, unfortunately, sometimes it sounds like it's more or less severe, but the degree of a felony really pertains to what is the highest level of punishment that can come out of it. So when we talk about first degree murder, keep in mind Florida is different than other states. So there are some states that have first degree murder, second degree murder, third degree murder. Florida doesn't have third degree murder. We have what you'll hear people call manslaughter. But the difference with first degree murder is you're looking at an element that the prosecutor can prove of premeditation. Premeditation can be the snap of the fingers or the blink of an eye. But at the point where the prosecutor can prove premeditation, that's when you're looking at a first degree murder charge. Where when you're looking at second degree murder is, you commonly hear it referred to as depraved heart. The scenario they teach you in law school is when you walk into a room and you see one of your family members being harmed, and you take some sort of action that's unreasonable for whatever it is, and that person ends up dead. These things are all kind of sideways complicated, where Florida has a concept called felony murder, meaning that if you're engaged in the process of a felony, so you might be engaged in a bank robbery. And if somebody's engaged in a bank robbery, which is automatically a second degree felony, and a security guard ends up being killed as part of that, even if it wasn't the bank robber's fault, the bank robber who was involved because they were involved in the felony can be charged with felony murder, which will bump it up one level to first degree murder. So they're all very fact specific, and they're things that the prosecution discusses at great length with the family, usually before the charge comes out.
And what is capital murder? Diane asked what capital murder is.
So capital murder, I mean, any capital felony is something by common law that you could be put to death for. So anything where you could have the death penalty, that's when you hear the term a capital felony or capital murder.
Okay. And I know, again, we're very knowledgeable about Florida criminal justice, but remember that might not translate to whatever state you're in. And, so always ask specific questions to people in your jurisdiction if you have them. But in Florida, a lot of people don't realize that the state cannot charge first degree murder, that a grand jury has to indict on first degree murder. So everybody is charged in a murder case. What's that?
For the death penalty.
For the death. Yeah. So everybody is charged initially with second degree murder, and it has to, there has to be an indictment for first degree murder, which usually comes at a later date.
Well, Florida has a notice requirement too, where you have to issue a notice that you're going to be seeking the death penalty.
Yeah. So all of those things obviously make, navigating the judicial process complicated, because they're all very case specific. We're throwing all of these different scenarios at you, and the only one that you need to know, obviously is the one that is relative to your loved one's case if an arrest happens. But these are always good things to know, so that when you do go down and you sit down with the prosecutor's office, which most prosecutors I know do have a meeting with the family at some point after an arrest is made and those charges are filed. If they haven't, then that's something you should reach out to them and request. But these are always good. This is good information to have with you, so that when you show up, you can ask questions that will be pertinent to your case. And you can ask, what is this person charged with? What are the possibilities of a plea deal? Are you going to upgrade the charges to first-degree murder? Why isn't it first-degree murder? We have, like you mentioned, Rich, I mean, this was very enlightening for me sitting through a trial one time, and the closing argument, and it was a strangulation case, basically. And they had charged first-degree murder because they were saying it was premeditated because the defendant had time. Choking somebody and strangling somebody takes time. It doesn't happen instantaneously. So the argument for the state was that this individual had to sit there and squeeze this person's neck and look in their eyes and watch them. And at any of those moments before they died, they had the opportunity to stop. Mm-hmm. So that fits into that premeditation legally. A lot of times we think of premeditation as, you get to my house and you find a journal of explicit details about what I'm going to do. Right. That was premeditated, but that's not legally the definition. Legally, you just have to have, the ability to stop what you're doing, basically, right?
Premeditation is faster than most people think, and it's the lawyer's job to educate the jury on those things. And you're talking about why aren't charges up, and it's not just the prosecution and it's not just the defense. When a case goes to trial, there's many times that you'll see in the jury instructions what are called lesser included offenses, meaning that, sometimes there's no doubt that the person was killed, and there's no doubt that that the defendant was involved in that person's killing. That it'll come down to premeditation, and then the jury is the one, when they go back and conduct their deliberations, they may be the one that come back with what's called a lesser included offense, meaning that they may not have found the premeditation, but they did find kind of that depraved heart concept of murder, and they still find them guilty of the lesser included offense, which is second-degree murder.
And again, in Florida, second-degree murder is still punishable by up to life in prison. You're not going to get the death penalty with second-degree murder, but you can still get life in prison without the possibility of parole with second-degree murder. So there's that overlap, in those charges that I know I've seen families that were distraught because they felt like it should have been first-degree murder, and whether it was the prosecutor or the jury finding a lesser included offense of second-degree murder, that's what the conviction ended up being. But the sentence still was the same, especially, particularly cases that were not death penalty cases. That's still a life, potential life sentence. So remember that. And this is going to be something new for me. Michael asked, can you explain Alfred pleas? What does that mean? Who is Alfred? I've never heard that, Rich. So
an Alfred plea means that a defendant legally has the right to enter a plea in their best interest or their convenience, where they don't have to specifically state that they are guilty in committing that plea. So it's an understanding through the court system, because there were times where courts would reject those types of pleas. A judge would say, look, if you're not going to plead guilty, then I'm not accepting your plea. And the Supreme Court came back and said, look, if somebody's going to enter a plea in what they consider to be their best interest, and that can mean a lot of things. It might be in the defendant's own, we'll call it wisdom, that they feel like they shouldn't have to go through a trial, and because of that, maybe that's the reason why they enter what you hear called as an Alfred plea.
Okay, that makes sense. And I have heard the judge ask, during a sentencing hearing, are you pleading guilty because you are guilty or because it's in your best interest? So you don't hear that, I guess, a lot with that term with murder investigations. I haven't, at least in my experience. But
No, it's not usually done in a murder case.
yeah, it sounds to me it's like a no contest plea. You know what I mean? Like sometimes you're not going to admit guilt or not, but you realize that like.
So no contest doesn't, I mean, it accepts that there's a factual reason for entering the plea, but it really doesn't go beyond that. Alfred's a step further where you are actually pleading guilty, but you're pleading guilty in your best interest.
Okay. That's interesting. I appreciate Michael asking that, because that was not something I had ever heard before. So I learned something tonight too. A lot of times we hear, you may not know the answer to this, but so the cost of a prosecution, like a murder trial, the expert testimony, flying witnesses in from wherever they, may or may not be, even depositions and time. Do you have any idea like what it costs the taxpayers to prosecute a murder case?
That's a loaded question, and it really depends on how much the defense wants to fight certain issues. A lot of defense attorneys will narrow issues, meaning that they're not going to dispute that the person's dead. I mean, believe it or not, sometimes you're charging a murder and the body's been missing for 10 years. Whether or not the person's even dead becomes an issue. When you get into depositions, when you get into testing physical evidence, if you have your own expert or defense experts, a number of times it's probably not surprising that you're dealing with people that have mental health issues. So whether or not they're competent to stand trial can affect a whole different tangent on your case as to whether somebody was, and this isn't just the not guilty by reason of insanity. Sometimes they either malinger, meaning they fake whether or not they're competent, or sometimes they have mental health issues that are so entrenched or severe that they really can't stand trial, and that process alone. So, I mean, it's not unheard of where a prosecution can be tens of thousands of dollars all the way up to six figures to prosecute a case.
Yeah, that makes sense. It depends on the case. We got a couple more things I want to get to before we wrap up. So Jennifer asked, how does a victim's family reach out for legal support? And I think that's kind of a tricky question too, because if an arrest has not been made, can a family reach out to their state attorney's office, and will somebody sit down with them and explain anything? Should they refer to their area legal aid?
Yeah, legal aid at least what I've seen from different places I've worked, doesn't handle as many criminal cases.
Right.
I would say your starting place would be your state attorney's office or your district attorney's office. Many times, like you said, there are homicide prosecutors that are on call. And if your prosecutor's still with the office, they still have that case, and they're able to pick up the phone and talk to the detective and see if there's been any developments or improvements on the case. But they also understand the process, and they can explain, kind of as we talk about things being fact specific, they can talk about what facts are important for your case, what pieces of evidence we're still trying to find, what things are important before they get to a point where they believe they can file and prosecute that case.
So there you go, Jennifer. Start there and see if they can, if somebody would be willing to sit down with you. If an arrest has been made in your case, then absolutely you reach out to whoever's prosecuting that case, and they should be more than willing to sit down and have a meeting with you and talk about what's going on. But I kind of get the feeling that you maybe don't have that option, so you're trying to figure out who else to talk to. So start there and see. You can also reach out to our office. Obviously, we're not attorneys, so we can't provide legal advice. But if it's questions about the judicial process, we might be able to help more specifically, with your case if you call us on the phone. So consider that option as well. Two more things I really want to hit on, Rich. One is the victim's property, personal effects. So a lot of times whatever's collected at the scene is kept in the property room until a trial. and then
Right.
often after a trial, depending again on how that trial goes. So um, circling back to plea deals, a lot of times when that plea deal happens, the evidence in that case, and I'm not talking about, guns or physical evidence that might be in that case, but I'm talking about like personal property, like jewelry, earrings, watches, bracelets, necklaces, um, stuff like that, wallets, IDs, stuff that the family would want to have back as memories of their loved one. And a lot of times they can't get that back until the trial. In a plea deal, they're going to have the opportunity likely to get that stuff back a lot faster than if it was a jury trial. And then again, if it's a death penalty case, you may never see that stuff again because of all the appeals that go along with that. But how does that process work? We've helped a couple of families get things, usually after a plea deal or after a trial has ended for a while. And again, not stuff that was necessarily, evidence that was brought into evidence at trial, I guess I should say. It might all be evidence, but it was physically brought in as evidence during the trial. So what's the process and what's kind of the decision making on what is allowed back to the family and what isn't?
So it kind of seems odd, but from a prosecutorial standpoint, everything is evidence. And everything is evidence because until you're in that trial, I mean, presuming the case goes to trial, you don't always know what the defense is going to bring as far as what their defense is. The second kind of component of that is there are scientific advancements that have occurred even over the past couple of years, which are very different with DNA analysis. There's very different scientific advancements that exist today that didn't exist 30 years ago. So if those things had been discarded, you may actually be losing something that could confirm a conviction and even support an appeal. So if you go to trial, and as you were trying to allude to, and the person is convicted at trial, understanding that there's a good chance there's going to be an appeal, as a prosecutor, you don't want to let go of the evidence on the off chance that it's going to be reversed on appeal. And that's why, as you talked about, when you deal with a plea, a lot of times there's a little more security that the conviction is not going to be overturned when you're dealing with a plea. But even though it's something that may seem unimportant or not evidentiary in value, even things like wallets and IDs, when you get to the point where you're in a trial, aside from all the legal noise involved in a trial, the prosecutor's job is to tell the jury the story of what happened. And, a lot of different aspects of personal effects help tell the story of that person's life, what they were doing, why they were there, kind of what brought them to the certain point that the homicide occurred. So even though it seems like something that wouldn't be needed for a trial, there's so many different circumstances that you don't know. As far as how to get those things back, that's a good thing to communicate with if there's a victim advocate or speak with the prosecutor to ask them, look, do you really need this for the trial? And they'll think about it. And if it's something they don't need, I've never seen a circumstance where they wouldn't return the property to the family member.
Yeah. And particularly, like I said, we've had a couple of situations where it was a plea deal. It's now been, a period of time after that plea deal, and the family realizes, oh, I'd like to have that necklace back, or I'd like to have, their watch back. And in our experience, every time we do that, every time we reach out to the prosecutor's office, they're more than willing to release that evidence back to the family. But there's a process, and there's some paperwork that has to be filled out, and there's some, you have to go down to the evidence room. They have to, get that sheet over to the evidence room so that they know that you can release it, and they'll only release it to a specific person typically. So you have to take your ID in there and prove you're the person that it's being released to. But that's an option for some families, and a lot of times that just kind of gets forgotten about. But every now and then we have a family that reaches out and says, I'd like, is there any way I can get something back? So that's the way to handle that. And then, Rich, the last thing I want to talk about, which is, kind of one of the more important things, but I think we can talk about it pretty quickly, is we have situations where a suspect is known, or at least 99% known, where they've had witnesses come forward and say that they are that they saw who did it, but there's no physical evidence to connect them, or maybe your eyewitness isn't reliable. Maybe the eyewitness has a reason to try to pin it on somebody else, and that's all you have, and you can't prosecute them. You can't, there may be enough for the police to arrest them, but probable cause. They may be probable cause to make an arrest, but there's not enough to charge. And that happens more than we would, really like to admit. But can we talk about that a little bit, and how you make those decisions? Do you guys have like a checklist where you're like, okay, we have this physical evidence, we have this eyewitness, we have this, or is it round table? Do you sit with your colleagues and say, this is a circumstantial case and we don't have physical evidence, but we have this, and this that are all circumstantial, is that enough? As I know that's frustrating for families when they're told by police, hey, we know who did it, we just don't have enough evidence to charge them.
Right. And that's a big part of it, where, a prosecutor's obligation is to bring forth the highest charge that they believe they can prove beyond a reasonable doubt. And that is not an easy burden to overcome. And when you're talking about taking away someone's liberty, or sometimes someone's life as a defendant, you have to make sure that you can prove that case. Candidly, I mean, you'll end up traumatizing the victim's family as well if you take a case that can't be proven, and then the defendant that you think, or you're pretty sure committed a crime or committed a homicide, ends up being acquitted. So, the threshold of, I've heard defense attorneys, I even heard defense attorneys say this in a trial once, is he said it to the jury, that if you think in your mind that you're pretty sure he did it, that equals not guilty. That is a not guilty result that you are required by law to find, because the law doesn't allow us to convict people because we're pretty sure they did it. You have to know beyond and to the exclusion of a reasonable doubt that someone committed the crime based on the elements of what you've charged. And, if you can't prove that, it's really irresponsible for a state attorney or a district attorney to bring forth charges that they can't prove. And I don't know anyone that does that. So that's a complicated aspect of what's looking at. And, you're right, there might be a witness that says, I saw this murder. And you may not realize that witness may also be a convicted felon. And, sometimes these things happen where the credibility of that witness leaves a prosecutor where they want to have something tangible or additional, or sometimes what the witness says, there may be a security camera or a video camera that differs slightly from what the witness saw happen and what you see on the video camera. And those conflicts in evidence are things that, as an attorney, are going to come up in trial. So you've got to find ways to shore up the case if you are convinced that the person committed the crime you're charging with.
And I mean, this is why we have defense attorneys and judges. There's a check and balance system where if a prosecutor does bring a defendant to trial in something that there's no factual evidence, to show that, that's why these defense attorneys at every turn are asking to have the charges dropped, because they're saying, look, this is not proof that my client did X, Y, and Z. And it's really up to the judge before it ever reaches the jury to kind of make that determination that there is enough here. What the state has provided is enough for a jury to make a determination. And so there is a check and balance system. So you can't force the issue. You can't just say, because a family really, really wants you to, you can't charge somebody like that, because there's things like prosecutorial misconduct, and there are consequences for those actions, and there are checks and balances to make sure that the people we are prosecuting and that we're convicting are in fact guilty, because we know that Unfortunately, that's not always the case too. Otherwise, we wouldn't have things like the Innocence Project, you
Right.
know, and have those stories coming out. So I think we would all agree that there's no justice in convicting the wrong person, you know. So none of us want that. And then the reality of charging somebody when you don't have enough evidence to prove it. And let's be honest, Rich, when you're talking about 12 jurors or 6 jurors, whichever the case may be, you never know what they're going to do. You can't get inside their minds. You do your best to pick the jury that you think will be unbiased, will listen to both sides, and will make the right decision. But you don't know what somebody may believe and what they may decide as a juror. And so you always have that risk of somebody being acquitted and walking out of the courtroom not guilty.
Or even worse for your victims, or a hung jury. I mean, you could have death penalty case where you have 12 jurors, or a federal case where you have 12 jurors, and 11 of them think you did it and one doesn't, and one's not going to budge. It could be 2 that aren't going to budge, or 3 that aren't going to budge. And when you have that hung jury, I mean, the very short answer is you're trying that case again, and that's traumatizing to a lot of people, because you're expecting some degree of closure, and it doesn't always play out the way we want it to.
Yeah, we definitely don't want, I think, the prosecutors don't want to see have to face a family after a not guilty verdict. You know what I mean? Or have to face, see them again in trial for another trial. So this is all very complicated stuff. We got 2 questions that came in that were really good, so we want to get to them, and then we're going to wrap up. Rich, Diane chimed in and said she was actually given the watch and other personal property shortly after her husband's murder, which is still unsolved. Why would they release evidence so early?
Well, I mean, sometimes there is a determination that it's not of any, you'll hear the term, it's not of any evidentiary value. It's not that it's not of value. It's just, it doesn't help prove or disprove one of the elements that the prosecutor has to have in a case. And in those circumstances, they should return the property to the family member.
Yeah, and we've seen that too. We have another situation where a family member asked, and the state attorney's office and the detective went through the property list. They determined that there were a number of things that held no evidentiary value, and offered to give those back to a young woman whose mother was murdered when she was very, very young, and she just didn't have any real mementos from her mom, any physical stuff that belonged to her mom, because once her mom was killed and she was a little kid, she just went to go live with somebody else, and it was the adults that handled any property or anything that the mother owned. So I think, open lines of communication and talking, if you can pitch your good point why why you should have some property back, and it's not of evidentiary value, you have a good chance of getting it. Just remember, you don't want to be the one responsible for taking that evidence out of the property room and then them needing it at a later date, because
it won't be usable at that point. You lose.
Yeah, once it's out, it's out. It's the chain of custody is broken, and it can never be brought back in. So just be cognizant of that. And then Jennifer asked, so if there is an arrest for first-degree murder, there is obviously enough for a DA to move forward, correct?
Well, no, because the threshold to make an arrest is probable cause. The threshold to convict is beyond a reasonable doubt. Those are 2 very different burdens of proof, or kind of ideas. And, usually, at least I guess I'm fortunate to have worked in a place like Jacksonville here, where the sheriff's office and the prosecutors talk frequently, and they have a good relationship. And, I have heard stories of other areas of the country where that's not always the case. Sometimes your DA or your state attorney's office doesn't get along with law enforcement. And sometimes they'll make an arrest, and sometimes the prosecutor feels like the case couldn't be charged. So I haven't seen a whole lot of that. Usually for us, there's a lot of communication where the prosecutor and the detective or sheriff's office or police department are on the same page as to whether or not an arrest needs to be made.
Yeah.
But in the case where if an arrest is made without the prosecutor, I mean, there are times where, law enforcement's told one thing by a number of witnesses there, and they believe they've got the right guy. And it's not common, but you hear the stories where somebody comes in later and says, well, I did it. It's not that guy. And that creates a problem for the case. So something like that, you're forced to drop the case.
And we have a specific case on our wall of a family who the agency made the arrest when the state attorney's office told them not to, said we can't charge that case, but they made the arrest anyway. And then what you're looking at then, if things aren't handled properly is, remember what we talked about with speedy trial. So once that arrest is made, the clock starts on that speedy trial. And if not, there's a proper way to dispose of a case where you can come back and charge, right, Rich? But
well, not once an arrest is made.
Yeah. So, and that's what happened with this family. The arrest was made, which meant the clock started, which meant when there wasn't enough evidence and 180 days went by, speedy trial ran, and now they physically cannot rearrest and charge that defendant. I guess that's double jeopardy because he's already been arrested, even though it never went to trial. So, you want to talk about a police officer who feels tremendously guilty because he got a little anxious and made that arrest, and now that family will never have justice because they legally cannot rearrest that individual. So, so I hope, Jennifer, that helped. Remember the difference between the police and the prosecutors. One can arrest and one can charge. Basically, it's not quite that simple, but for these purposes, the police make the arrest and the prosecutors charge with the crime. And you have to have both of them working together to be able to successfully prosecute a case, make that arrest, get a prosecution, and go to trial and hopefully receive some justice. So reach out to your law enforcement and your prosecutor's office and try to clarify, because typically the police don't arrest for first-degree murder. They arrest for murder, and then whatever the specific charges are done by the state attorney's office. So so that may clarify. Rich, thank you so much for your time tonight and for helping us clarify some of this, educating us. Everybody learned something new tonight, I'm sure of it, because that was a lot of good information directly from a source that has been there. So it's much appreciated, and thank you for your time.
Thank you.
All right. Thanks everybody for watching. Remember, this month is our virtual Year of Hope. Every day on Facebook, we're sharing stories about Project Cold Case and what we do. We're sharing workshops like this one. We just launched a new cartoon of a young girl named Dawn whose father was murdered when she was a young kid. We're going to be releasing those monthly that you can follow along with, that will explain to those that haven't been impacted by homicide some of the struggles that we face. And for those that have been impacted by homicide, it's going to help show what things you can do along your journey to assist in your loved one's case by raising awareness, seeking help from other survivors and stuff like that. We've got a new series called Not Forgotten that are 1-minute clips of cold cases from around the state that we're going to be sharing later on in the week. We've got an ongoing fundraiser, and we will have our official Year of Hope event virtually this year on Facebook. So that'll be later on in the month that will coincide with an online auction. So keep up with us on Project Cold Case Facebook page and projectcoldcase.org. Reach out to our office if you have any more questions or needs or more specific questions about what we've been talking about. If you missed our conversation last week with the homicide sergeant, that's still up on our Facebook page. And join us next Wednesday when we hope to have a victim advocate in and talk about the ways they can assist and help you through your journey, whether it's a solved case, an unsolved case, a case currently in the judicial process, or anything along in between. So again, thank you, Rich. Thank you, everybody, for watching, and we will see you next time.